So like Taylor introduced, I'm Amanda Smith. I am a senior associate here at Tully Rinckey. I regularly handle federal and New York State labor and employment cases. So EEOC cases, MSPB, if you're a federal employee, wrongful termination, wrongful disciplinary actions. I also have done a couple federal court as well as New York State court matters, again, associated with labor and employment. So I know last webinar, I believe, the informal EEO complaint process was discussed. So today we're building off of that and going into the formal complaint. So things that we'll be talking about, or I'll be telling you about, and you'll be able to ask me questions if you haven't already. What to do, when to file the formal complaint, what the process is, what your deadlines may be as you come through the process, when you start it, as you go through the investigation, what comes after. We'll discuss, what you can expect to get at the end of an investigation, what documents will be provided to you, and what deadlines will come about at that point, as well as potentially what choices or options you'll have when you get that report investigation, what kind of litigation you could do. And well, we might not go into too much depth. I'll at least go through your options with you. So if we can go to the next slide here. So from the informal to the formal stage, when you are filing an informal complaint, remember that you have 45 days from whatever date it was that the last action happened. So whether or not that you were potentially given a suspension, letter of reprimand, someone said something that they shouldn't, that you believe is discriminatory or retaliatory, that's when you have to file that informal EEO complaint. Well, when you get through the informal complaint phase, which if you elected to do ADR or mediation, it was unsuccessful, or you did traditional counseling, which is you tell the counselor what happened, you go through the issues, why you believe it's discrimination, retaliation. The counselor should be asking you questions. They should ask you what damages or what relief you want to see come about from the complaint, and the counselor goes to the management. They may discuss and get their side of the story, come back to you, see if they offer to do anything. That's traditional counseling. Mediation, as you probably know, that's where everybody sits down at a table on a specific day, or in this day and age, it's probably on a computer or on your telephone, and everybody discusses what happened. Everybody has an opportunity to respond and to discuss everything from all sides, and discuss if there's a resolution. If there's no resolution in traditional counseling, there's no resolution from mediation, then you'll have the right to file a formal complaint. The formal complaint, it's the same claims that you've raised at that informal stage, but you get what's called a notice of right to file, or a notice of right to file a formal complaint. Depends on how many words the agency wants to put in that letter, but it's the same right. You'll have 15 days from that notice to file a formal complaint, which basically triggers the other side of the EEO office to start an investigation into your claims. So up until that point, it's just going to be communications between you and the counselor. After you file a formal complaint, that's when you could be expected to communicate with an investigator. You'll get a case manager or someone to that kind of effect, maybe different titles, but it'd be someone different than your EEO counselor. Some agencies have specific forms which they are supposed to provide you within that notice of right to file letter. And it does provide you the contact information, the office information, and a couple other details of what you could expect your rights to be for the formal complaint. It's very important to keep track that you have to file that formal complaint within 15 days, calendar days, not business days, of getting that notice letter. If it's beyond that, it can be untimely. There's not favorable case law for, without good cause, which is very debated, and I can probably spend a long time discussing what that means. But just, I can't stress enough, keep track of the 15 days. If you know you're going to continue it, file the same day or the day after. It's just copying and pasting the information that you already did for your informal complaint onto that formal, just to preserve your rights, making sure you meet that 15 days. Now, there's a couple things you could explore. That's still a 2-week period of time. So, you could reach out in that time frame to talk to an attorney. They could give you an initial, maybe an assessment of your case. They could lay out what I'm doing here. They could lay out more of what to expect, maybe experience they've had themselves with the agency that you're battling. They could probably go through with you, what terms of damages you might see from your complaint, or what you may be wanting to establish during that investigation. So it's a good time, to create a timeline of events, put together all of your documents if you haven't already. If you have an email between two people that you know evidences the discrimination or the harm, you have a counselor putting together that type of information would help you during the investigation, but could also help your attorney or an attorney in trying to assess your case as well. So once you file the formal complaint, I believe I went through some of this here. After you file the formal complaint, at that 15 days, you'll file it. They should send you some type of correspondence. If you filed it via email, they should send you something saying that they received your correspondence. Some agencies, like the Postal Service, you still have to mail in a formal complaint, so you may not receive something back for a couple weeks. If that's the case, if you have to fax or mail your formal complaint, or even if you do email it, but any manner in which you're filing it, make sure you save receipts. Mailing receipt, if you can send it certified where someone has to sign it, it gets a tracking number, something like that, so you can be sure that your formal complaint gets to where it's supposed to get to. Faxes as well. Sometimes faxes fail. Make sure that you steadfast watch that it went through, get the confirmation. If there's issues later, you have a piece of documentation that shows that you filed it on X date. The other thing to expect is once you do file it, you may get that immediate acknowledgement that they've received something, but they should also, your agency should also be issuing you an acknowledgement letter. An acknowledgement letter is just assigning you, if they haven't already, assigning you a complaint number, acknowledging that you filed your formal complaint on X date, so it's creating a written record that it's timely, and walking you through probably expectations of what to expect for the EEO complaint. So each one of them might be a little different, but they'll usually say, 180 days for the investigation, what your rights are, what to expect. If you don't get, things timely from the investigator, what can be done, what to do with your report investigation, those types of things are pretty standard. Some agencies have also been issuing, alongside the acknowledgement letter, like your electronic rights as a complainant, how agencies are processing these complaints during the COVID-19, post-pandemic era. So you might get a couple other documents alongside that. After the acknowledgement will come where the agency reviews the actual claims that you raised. So in the informal phase, the counselor is just going to write down everything that you state to her or him. They're going to, go through and try to frame your statements as claims or things that are actionable. So if you say that, I was suspended on X date, the counselor is going to try to write that out, but you might be giving more detail. At the formal complaint, there will be the counselor's report. So whatever that person creates, they will send it alongside the documentation you submit for the formal complaint. And then you will have a separate person. Reviewing what you filed and making sure that you raise the same issues before the counselor. And they may, if it's not clearly written out, on this date I was suspended, they may try to piece that together from whatever narrative you submit. It's important when you get what's called an acceptance letter or a dismissal letter or partial acceptance, partial dismissal. It's very important you read through those claims. Make sure everything that you wanted to bring up in your formal complaint was brought up. You will get a case manager. That's the individual who will be sending you this acceptance or dismissal or some combination of the two. You can contact them within, it varies by agency, but it's either 5 or 7 days in most cases, telling them, that you object to how they framed your claims, that they missed a claim. It's possible, it's very possible that they did. So making sure that you put that in writing, whether it's by a letter and email to that case manager, asking them to include that claim that they missed for multiple claims or correct a date or a name. That way that if they don't immediately do so and issue you a new acceptance letter or dismissal letter, that then you can include that correspondence in your report investigation. And later on, if, depending on the choices you make for continuing litigation, you can bring it up and ask that claim be reinstated or corrected. So there's multiple benefits to doing that. I encourage it. Also, there's a chance that case manager revises that acceptance letter, includes the claim, and you get it investigated. Now, after you get the acceptance letter, it basically creates the roadmap for claims that an investigator is going to take and investigate. So that individual, different agencies, again, do different things, but it might be a contractor. It could be someone at another federal government agency who's an investigator for EEO claims. Typically, it's someone outside of the EEO office, or there's some level of, or supposed to be some level of neutrality with whoever they assign. Now, investigators, they are still federal employees. Not all of them are law enforcement or prior law enforcement, but they are someone who is supposedly trained in collecting evidence or interviews and information for this type of purpose. So after you get that acceptance letter, they will assign an investigator to your case. Right now, there are differences in processing times. It could be a week, it could be a couple months. I can't really give guarantees on how fast or long it's going to take for an investigator to be assigned to your case, even if I'm going based off of estimated timeframes from a previous case at the same agency. They should be relatively quick being assigned to an investigator, but it doesn't always happen, especially after the pandemic. There's staffing shortages and issues along those lines that have really affected the EEO process. However, you'll still get an investigator assigned. They will either schedule an interview with you over the phone, maybe by Zoom, or they'll send you created questions in a format of a statement. They will be very, very broad to detailed questions. They will basically be trying to get as much information about whatever claim you have as possible. So say, as I'll just keep with the same example, say that you have a suspension that you received. They'll ask, when did it happen? Who gave it to you? Who was involved? Why were you suspended? Why did you disagree with it? Did you tell so-and-so that you disagreed with it? What was their response? Did you talk to anybody else about it? Why do you think that this was discrimination? Why do you think that this was retaliation? And they'll go through all of those things. Was it in violation of a policy? So you could have 5 claims, and you could have, a statement if they send it to you in writing. It could be 20 pages long. Now, you'll probably want to answer all of those questions at once, or in the grand scheme of things, it's going to a paragraph or 2 paragraphs to completely tell about an event. But it's just to provide a guide, and it's to collect all the information that may be needed associated with that claim to put it on the record for eventually when they go talk to witnesses or management officials, individuals who you claim were harassing or as part of the discrimination. It will give them the information to question them about. So they will talk to you first. Once an investigator is assigned, they may ask the EEO office for information. Typically, they might do that apart from you, and then they will either ask you for your interview or your statement. After they get your statement or they do your interview, they will then talk to management officials, witnesses, so that when you talk to the investigator, this is your time to provide them all the witnesses that could be relevant to your case. I strongly recommend doing them in order of most important to, supplemental to someone who may be able to talk about your complaint. You want to make sure that, right out the gate, you're identifying everybody who could be involved in your case. That way, there's no surprises later on, and you're able to ask questions about those individuals. You're able to call them as a witness in a court case, those types of things. So it's just important. And then for your own keeping track and records, making sure that you have all the details. That timeline I mentioned when you were starting to think about filing that formal complaint, all of those things would be really helpful for when you're answering these investigator questions. So after they talk to you, they talk to the management officials for their side of the story. You should be able to rebut or respond to anything that is that your management official is bringing up. So if you say X, they say Y, you're able to say, no, that's incorrect, so this is what actually happened. Sometimes management officials bring up new information. They talk about an event that was 4 years ago. Well, obviously, it's not something that you're thinking of. So in that rebuttal, that reply, that's your opportunity to respond to that, provide more information, get it on the record. They may talk to witnesses that management officials provide that should be that they should talk to. They may provide information about an HR specialist who they consulted with, those types of things. The investigator would have the authority to reach out to that person, ask them for a statement, do an interview. Now, the investigator does not decide the merits of your case. It's frustrating, I know, but when you go through the formal complaint, nobody should be making comments about the merits or the facts, whether or not there's discrimination, retaliation for your case. It may become obvious, maybe, from what management provides. It may, there may be answers that you are shocked with that, maybe an attorney in my same position would not be telling someone to say on the record, but there's not going to be any decision. The investigator is not going to make recommendations. Like if you maybe undergo an investigation for disciplinary action, sometimes those investigators may make recommendations or advise management on what they should do in whatever situation, that they had a finding of this charge, that charge. And the EEO investigator will not make any decision or recommendation. All they will do is put together your statements, management statements, the documents everybody submits, witness statements. They will put it together in what's called a report of investigation, or an ROI, and they will give you that ROI. The ROI may come from the EEO office, that case manager that you were assigned, but regardless, it's going to come from the agency. You're going to be issued a full copy of that document. Depending on the case, it could range from 200 pages to, I've seen a couple that are 2,000 pages or more. That's purely associated with how many claims, how many people were interviewed, how many documents you submitted, management submitted. There's no specific reason why it may have, or there's variation. It's just associated, it's all of the documents associated with your complaint. So once you file that formal complaint, the agency, which includes the investigator, will have 180 days to process your complaint. Now, that's 180 days from when you filed your formal complaint, not when they issued the acknowledgement, not when they issued the acceptance letter. 180 days is 6 months. You have the right to amend your complaint at any time if more incidents, whether they're harassing, whether you get another suspension, letter of reprimand, whatever it may be, you could request to your EEO case manager to amend your complaint to include new claims. You'll do it a little bit similar to how you filed the formal complaint, but you're making a request directly to your case manager, not maybe a general inbox. And you are specifically stating, that I'm looking to amend my complaint with these claims. And I would strongly recommend making them as clear as possible with dates, who's involved, what happened. The EEO case manager should acknowledge that, whether you're sending it in a letter or just in the body of an email. And they should process that and issue you some sort of amended acceptance letter. Now, if you amend your EEO complaint at any time once that initial formal complaint was filed, you will have 180 days, or the agency will have 180 days to investigate your claim from that date. So say, to make that a little clearer, say you file your formal complaint on January 1st. Then the agency will have 180 days from January 1st to investigate. However, say something happens on January 31st. Then you decide and you write a letter to the EEO case manager that you want to amend your EEO complaint to include this complaint, and you write to them on February 1st. Well, then the agency now has 180 days to investigate from February 1st. If you keep amending your complaint and say it will keep extending out the deadline, the 180 days, the agency can only extend out that deadline to 360 days from when you first filed your complaint. So even if you keep filing amendments and say you file an amendment all the way up until August or September of that same year, the agency won't be able to push beyond that, whatever the 360th day is from January 1st. So it's something to keep in mind. It could extend the investigation process or period, but there still is a cap on how long it's supposed to take the agency or how long they are permitted to do the investigation, even if you do so. To the next slide. So after you go through the entire investigation, you'll get that report of investigation that I mentioned. It is the collection of all the documents that the investigator has collected either from you, witnesses, or management, or HR, depending on the claims you have, and you will have the right to choose how your case continues. Now, you have three options when you get the report of investigation. Two options are something that it's more recommended that you choose. The third option, which I'll get into, it's kind of one of those I would recommend waiting if you don't have the funds. So first option is you request a hearing before an EEOC administrative judge. The EEOC, the Equal Employment Opportunity Commission, is an administrative court. It is a separate government agency with administrative law judges, not federal appointed judges. These administrative law judges are, they're supposed to have background in EEOC matters. They have different district offices, field offices. So if you're in Washington, D.C., you might get a different judge than San Diego than in New York. So they do break them up in districts and then in smaller field offices as well, like Philadelphia is to New York. There are, in some cases, there are only one judge in one specific field office. There are sometimes 20 judges in one district office. This has resulted in some backlog. So it's not abnormal that it could take anywhere between 6 to 8 months to get a judge assigned to your case. And it kind of, you're rushing to get through the investigation. Once you make that hearing request, don't be afraid if it takes a while until you get the judge assigned and go through the process. Now, requesting the pros of requesting a hearing, or what's essentially a trial before an administrative law judge, it's very similar to what you might think of when you think of terms of court. There's a judge, there's, going to be someone, some opposing counsel that's going to be defending the agency. You have the right to counsel. You will be the plaintiff or the complainant. It's your case. There's the burden is on you to demonstrate discrimination or retaliation. And you will have the opportunity to go through discovery, which is requesting documents. It's requesting maybe depositions or statements with witnesses, management officials, anybody that could be involved, information from the agency that maybe they didn't disclose in the investigation itself. So there's a couple things that you could expect if you went to court. It's very similar, different rules, but it's very similar in how it processes or plays out at the EEOC. Now, after discovery, there's motions. So the agency might move to dismiss your case. You'd have the opportunity to respond. If you survive motions, then you're going to a hearing. You're getting a lot of the same rights, again, that you would get if you went to federal court. Now, it does get costly to do the EEOC hearing process. It does last a long time. So, if you've done this before, or if you're aware, the wheels of justice don't always spin very fast, especially in America, unless they want them to. So you could expect, if there's an initial wait, 6 to 8 months for a judge, you could rush through the discovery process. It might take a while for a decision on motions to be had. In total, to get to a hearing, it could take a year to 2 years. It's not a short process. It is something that you have to, continue into the long haul. That's the cons. Now, on the flip side of the EEOC hearing, there is the possibility where you could request a final agency decision, or a FAD. A FAD is something that you request from a separate office at your agency. So it may be, if you're, having your formal complaint processed through the EEO office, your agency might have a civil litigation or civil defense office or division, whatever they may call it. They are the ones where you are requesting for them to review only your report of investigation and make a decision on whether or not there's discrimination or retaliation in your case. They will be looking through your evidence, the agency's evidence. You're not able to submit additional information or evidence, witnesses, anything like that. They're just purely looking at that report investigation. So there's no discovery, there's no motion practice. You lose a lot of leverage in trying to negotiate settlement. A lot of instances, it's not something that I would recommend you do right out the gate. And I guess the most important, other than the cons and the pros for each one that I listed, is that you have 30 days, calendar days, not business days, from when you get that report investigation to make your first selection on how you want to proceed, whether it's with a judge for an agency or final agency decision. You can always withdraw your hearing request at any point after that 30 days. So if you continue, you decide 5 months from now you don't want to do the hearing, you can always withdraw your hearing request and request a final agency decision at that point. You can do it all the way up until a hearing if you wanted to. But after 30 days, you cannot, after that 30th day, after you receive that report investigation, you cannot request a hearing with an EEOC judge. So the flip side is, if in 30 days you elect a final agency decision, you can't at any point withdraw that request and ask for an EEOC hearing. You have to continue with that final agency decision path. You can do the opposite. You can request a hearing, withdraw at some point, and request that final agency decision. So if I'm to advise you or recommend things about what to do, what preserves the most rights or options in the future, requesting an EEOC hearing is most definitely going to afford you the options to be able to choose what you want to do in the future if circumstances change. Now, there is that third option that I mentioned, and the third option at some point is always going to be available to you, and that is filing a complaint in federal court. Now, if you file a complaint in federal court, it bypasses the EEOC option for a hearing. It bypasses your ability to appeal to an administrative agency, the Office of Federal Operations. It bypasses your right to do the final agency decision. Also, there's just the same right to appeal that if it's not in your favor. There's a couple paths or options you have that if you elect to do a federal court complaint, it bypasses all that. And again, you can't go back. Once you make that election to go to federal court, you're not going to be able to go back or go to the EEOC hearing. You're not going to be able to request a final agency decision. You have to stick with federal court. And if the case is not decided in your favor in federal court, then your appeal right is to the Court of Appeals for your relevant district. And if that case isn't in your favor, your only option to appeal is to the Supreme Court of the United States. And it's rare that they're going to answer, an appeal election to the Supreme Court of the United States for discrimination or retaliation claim. So what I would recommend to preserve your most rights is to do that EEOC hearing. That gives you different options. Going to federal court right out the gate, it's not going to let you have multiple bites at the apple. You're going to have a limited number of appeals. There's also higher costs associated with federal court, more printing costs, more court appearances. There's more rules that have to apply to discovery, motions, that type of thing. So there's a lot more that I could probably go into, but to not overwhelm at this stage of what a lot of you would be worried about. There's the three options. You have to make the choice within 30 days, and the recommended path for a lot of complaints is going to be that EEOC hearing. So if we can go to the next slide. Now, so if you do elect to do the EEOC hearing, there is what's called the EEOC public portal now. A lot of things online these days. You're going to register and create your online account basically at some point when you are electing to do a hearing, or your hearing request is docketed and you get either a judge assigned or an EEOC case number. You're going to have access to any document that may be filed in your case right online. You'll be able to download documents that are either the report investigation, the acknowledgement order, whatever may come through either from the judge, your representative, the agency, that'll be accessible to you on that portal. It's not very complicated. They usually do have a process, it's a click through and you submit everything and it should spit back some email to you to confirm you're registered. They do have a helpline. I have used it. Everybody, in the beginning had issues with these, but they seem to have ironed them out a lot. For federal employees, it's important to remember that you don't submit your informal or formal complaint through the EEOC portal. Everything that you're going to be doing is with your government agency's EEO office. For private employees, you will have in the EEOC portal, and this is what the initial screen looks like, you will have the ability to file your informal complaint directly through the EEOC public portal. Now, if you file, they should spit back out at you. This is again for private employees. They should spit back out at you a date for an initial interview, or when your investigator is going to contact you. It could be months into the future. If you have an attorney, there is a Form 5 that we are able to file on your behalf. Sometimes that does actually rush the process. Might not be an immediate interview, but you may get an investigator contacting you maybe within a month instead of 2 or 3 months. Now, if you look at the screen here, this is what initially comes up. You will, if you're filing your first complaint ever for private employees, you can click on the filing with the EEOC. It walks you through the process. If you are filing a hearing request, or say you've already filed your hearing request, you're trying to access your case, you'd sign in. The next screen that'll pop up will show all of the complaints, which you'll have a lot less on your list than say I do. I'll have access to every client. Yours will just be the cases that are associated with your email address, whatever you filed. You'll click on the complaint number. The rest of the documents will pop up in order, and it'll say when the document was filed or received by the EEOC public portal. You are able to add a representative in your case. It's right at the top. Once you click into your complaint number, it'll be right at the top. You'll be able to click through, add the name, contact information of your representative. When you do that, it will send an email to whoever you're identifying. They will be able to say, yes, I am their attorney. No, I'm not their attorney. And then be able to access your complaint after that. So keeping with, the election to do the EEOC. After, say you go through motions, you go through discovery, you go through motions, you go through a hearing, then you will have the judge issue a decision. It's going to be an initial decision. He is going to either make a ruling on just the merits of your case, or he's going to make a ruling on the merits and damages that are associated with your case. There is a right to appeal. That appeal right is both for you and for the agency or the employer on which your case is against. So say a matter or a decision is in your favor, you're not going to want to appeal it, obviously, but the agency could, and then vice versa. Say it's not in your favor, you could file an appeal. The judge will issue an initial decision, and the agency will have 40 days to accept or disagree with the judge's decision. Now, the agency's decision, which is also called the final agency decision, you will have 30 days, or the agency will have 30 days to appeal that decision. So obviously, if the agency in that 40-day period of time is going to fight your judge's decision, if it's in your favor, they're going to say, we reject the judge's decision, we are going to appeal. In your case, if the agency says, we accept the judge's decision that's not in your favor, you will have 30 days to file an appeal notice. In that final agency decision, it's going to give you your rights. It's going to give you a form for filing a notice of appeal. You fill out your information. The appeal is an administrative appeal to the Office of Federal Operations, which I describe it, it's the appellate division. It's the reviewing authority at the EEOC. There are a handful of attorneys at the EEOC who may review your case, and then they will make recommendations to the director. The director of the EEOC is the one who issues a decision from the Office of Federal Operations. After you file a notice of appeal, you'll have 30 days after that to file a statement or a written brief in support of why the decision should be reversed. This could be, if you're representing yourself, this could be a letter. It needs to, though, include all the details on which the judge got it wrong, if they ignored facts, if the judge analyzed the wrong law, they didn't consider what someone said, and they did an incorrect credibility determination of a witness. All of those things are things you can bring up on an appeal. You do also, at this point, if you don't agree with the judge's decision, you can also go to federal court. So as I mentioned before, you're going to keep getting the right at certain points as you go through this process to go to federal court. So going to federal court immediately eliminates these options that I've talked about so far, skips over that, you go right to federal court. At this point, if you're considering an OFO appeal, you could also consider a federal court filing complaint. You can go through discovery, motion practice, a potential trial or hearing. You still have the same rights, same process if you elect to do a federal complaint now that you did before. Which I got ahead of myself. This is mainly what I'm mentioning here. You can, same thing with, I mentioned, instead of doing an OFO appeal, you could do a federal lawsuit. You can also request to do an OFO appeal, Office of Federal Operations Appeal. When you get a decision, if you don't agree with it, you can also go to federal court at that point. There's pros and cons. It depends on the federal district you're within, whether or not you want to do the federal district court complaint instead of an OFO appeal. If at some point maybe you no longer want to do the hearing at the EEOC, maybe it's beneficial for you to withdraw and to try to go back to federal court. There's a lot of different options, and it depends on what your specific jurisdiction is, what your district is, on what might be recommended, your case. So I can only paint with so many broad brushes here in this webinar, giving you the information, but at some point, if you're making the decision to go to a judge, to go to court, to do this, to do that, it's really beneficial to at least have a consultation with an attorney, to just go through your options, what your case looks like, what you could maybe see come out of it, what your federal district is like. If you're in Washington, New York, California, you know, there may be different judges, different things. Maybe they're favorable to complainants, maybe they're not. Those types of things can weigh in on what choices you make as you go through litigation. And obviously the goal is the most beneficial thing for you. You wouldn't be filing a complaint if something wasn't wrong. Okay, so what we do, I guess, it all. We handle a lot of complaints from very beginning, from an initial contact to an EEO counselor to filing a formal complaint, mediation at any of those phases, filing a hearing request, going through discovery, responding to an agency motion to dismiss your case, filing a motion for summary judgment in your favor. That could be something that may be a decision you want to make. Federal court, it does depend. You have to be admitted into the district where you are, or be practicing, or have an attorney who is located there. But we have a lot of attorneys in New York, California, DC, Maryland, Virginia. We have, I believe, a couple attorneys scattered throughout as well, and then Texas. So depending on the district you're in, we also do representation in those federal court complaints as well, or can have a referral if it's in another district there. We also do any other type, EEOC, or before the judge. We do OFO appeals. There's a couple other rights you have, reconsideration of an appeal, those types of things that we can handle. If you ever did want to set up a consultation to discuss your case, and like I mentioned, what may be the best options for you, information that's something that we would want is, what happened, a brief timeline, an initial statement, this is when it all started, this is who's, making the actions or taking the actions, making the waves, who's involved, how long of a time frame are we talking about? Have you gone to a counselor, or have you sought medical treatment? Did anybody witness it? what may have happened. There's only so much, that you can write initially for maybe an hour to talk to someone, but the highlights, what's the most important thing to you should be the most important thing that you want to bring up to an attorney to talk about. Contact information is something important to keep track of. Who is your EEO counselor? Who is your EEO case manager? If you're at the phase where you have a judge, who's the judge? Do you have access to the EEOC public portal? If you don't, call that helpline. Make sure that they register you or they have the correct information. A lot of stuff is done online now, so the more contacts you have, the better it's going to be. And then if you do decide you ever want to retain an attorney, they'll be able to take that contact information and immediately get their notice of representation to those who it's relevant to, and be able to start working your case. A couple things to remember: discrimination is wrong. You're not supposed to just take it and move on with your life. It's kind of what's got us into this another arguable pandemic of people filing all these complaints or people not being able to get the relief that they want. And it's not acceptable. It's not acceptable to be retaliated against just because you filed a complaint. A lot of people, I think, it's gone too far. And I don't think, there's ways to do things without, breaking your wallet. I think I can speak for a lot of attorneys that if something wrong is happening, you should fight it. And however you can do that to help yourself, to put you in the best situation, that's going to be our goal. That's going to be anybody's goal. So if that's full-on representation, if we're advising and assisting, if we're having a consultation, it's worth it. That's all I can say. Now, you can consult an attorney. You're under no obligation when you do consultations to retain anybody, but it's something that I would recommend to at least get that initial feedback on what you're supposed to be doing, what your rights are here. What could you expect in the future? Maybe you don't want to retain an attorney now, but what if 6 months from now the agency attorney on the other side is saying a whole bunch of words that you don't know, and you want to have someone, talk to you about that? Maybe that's when you want to bring on an attorney. But you won't know that that's the next step unless you talk to someone. The online can be a good resource, but God knows there's not always accurate information when you Google things. So the internet doesn't always tell the truth. Sometimes just talking to someone, spending an hour, an initial, if it's a free consultation, if it's not free, usually that initial investment, at least so you're a little bit sane going into the next steps, that could help. When you go through the investigation yourself, if you don't have an attorney, the most important thing, other than all those dates and time deadlines that I've thrown at you, make a timeline of everything. It gets so confusing, it gets so detailed and convoluted. The farther you go out from something, and you're going to forget it. I tell all my clients, save the email, make a memo to file, send it to yourself, get that date and time stamp. You had a conversation with this person, write it down, make sure you have some note that 2 years from now, if you're getting to a judge, you're giving testimony, you can pull that, you can remind yourself. You have the timeline that, okay, this is what happened from January to December of 2017 when you're giving testimony in 2023. It's very important. It's something that will eliminate a lot of stress you may feel on the back end. I can't stress that enough. It's something that I would highly recommend. For everything else, the second important thing to that, creating that timeline, creating that contemporaneous record, would be remember your deadlines. If the judge is setting an order with a deadline for you to do something, for the agency to do something, it's important. It's an order from a judge. It may not be a federal court judge. It may be an administrative judge. Both hold the same weight. Both, if you don't comply with deadlines, can be detrimental to your case. It could result in a dismissal. The agency does it, could result in a dismissal from the agency. So for the agency in your favor. That's an extreme case, but just it could happen. So treat every single deadline as important as the next. Same thing goes if you're having to file something, filing that hearing request once you get that final report investigation, filing the formal complaint within 15 days. Those things, it can have a major impact on whether or not your case continues if you miss those deadlines. So write them down, calendar them. They are all in calendar days unless they explicitly say business days. So, but calendar days is going to hit faster than a business day deadline anyway. Rather be early than late. And then back to, I know I brought it up, back to something to highlight is this is a long battle. This is something that isn't going to be resolved with a judge typically in 6 months. This is going to be a 6-month investigation, then another 6 months to get to a judge. Then it could be another 3 to 4 months to go through discovery. That could even be extended because of issues. Maybe the agency didn't turn over information that they should have, and you have to get the judge involved. This is a long battle. You can stay committed. Again, there's ways in which you could have an attorney involved to save money when possible. You can do things like that, but don't expect this to necessarily be something where you're going to get a judge's decision in your favor or not in your favor within a matter of a couple months. Okay, so there were a few questions here submitted beforehand. I believe there were some questions also sent in while I was talking and throwing a whole bunch of information at you all. So the questions that we got before, I'm still going to do some of these briefly. I believe I may have answered some of them as I was talking. I tried to incorporate them. As for what should I do after the final EEO counseling review? If you are talking about a complaint, they give you, they should at that final interview give you your notice of right to file a formal complaint. Sometimes they send it to you in an email afterwards. I would recommend very strongly to continue your complaint. Obviously, if you're filing a complaint in the first place, you think there's something wrong. And at the very least, there is a good reason for you to go through an investigation and see if your gut feeling is right, or preserve your right to seek relief for what you felt was wrong. So I would, after you do that final interview, make sure you get that notice of right to file a formal complaint. If you don't receive the notice within a day, so you check your email and you don't receive that notice within a day of doing that final interview, follow up with your counselor. If it went to the wrong place, if they mailed it, if they did something, you want to make sure that they didn't do anything wrong. And, it's your case. You just got to make sure that they follow the proper procedures. For mediation, you don't have to do mediation. In certain cases, I always recommend it at that informal stage. If you do traditional counseling, you get a 30-day period of informal complaint processing. If you do mediation, you get 90 days. It's just more time for you to resolve your complaint. So I would recommend doing mediation at that informal stage, because what if they're willing to do something to help you now, as opposed to you having to go through the entire investigation and 2 years from now you get a decision from a judge. It's just, if you could resolve something now, if it's a possibility, you would want to know. If you leave your agency during your EEO complaint, your complaint will still go on. So kind of think of it as, the harm, the actions have already occurred. So you don't need to be a federal employee or an employee of that agency to continue litigation against them for something that they already did. It could affect the damages or the relief you may receive, but it's not going to prevent you from filing a complaint, whether in federal court, before a judge, requesting a FAD. It's not going to prevent you from doing any of those things. Moving through the process. What can be requested from discovery? that's a little bit farther in depth and beyond this webinar, but it's any information that could be related to your case. So sticking with the same example of a suspension, if you've been suspended, information you may want, did the management official talk to anybody about the suspension? Did they get HR involvement or email correspondence? What was said? You could request the emails themselves, instant messaging. Did others in the office from that management official, did they receive a suspension? What for? Things of that nature you could request. Summary judgment. I can probably spend an entire hour on summary judgment. If the judge issues summary judgment, it depends on why. There are some judges who attach a piece of paper to the agency's motion and say, summary judgment granted, I adopt everything that the agency says, continue as normal. Those, I would say, maybe not as discouraging as the judge who walks through the entire case and gives explicit, reasons or cites to the case, the report investigation, other documents, and does a complete analysis. So there are reasons each agency is going to do it, or each judge is going to do it for. That's kind of a case-to-case basis. And something, if that's what you received in your case, definitely worth a consultation to see, is it worth it to keep fighting? A top one, can a court dismiss final agency decision? If so, what are the implications? I'm not 100% exactly what the intention for dismiss was. You can, though, say you, instead of going to an EEOC judge, you actually requested a final agency decision. You can appeal that final agency decision. You can go to federal court, or you can appeal it to the Office of Federal Operations. The Office of Federal Operations can reverse a final agency decision, though I am going to say it's probably more rare. There's not a lot of information outside of the report investigation. So obviously an investigator is only going to have so much ability to get information that the agency or you don't turn over to them. They're not going to be able to demand, email correspondence and do things like you would in discovery if you were with a judge or at federal court. So OFO, whether or not they reverse it, I can't really say that there's a strong probability. Now you go to federal court. If you're going to federal court, it's a start over. You're going right. It's an initial complaint. You're doing discovery, motion practice, a hearing. So they're not going to be very concerned, other than maybe the agency the reasoning or a document as part of discovery and use it and trying to argue that it was correct. Now a couple other questions I see here. FADs, there are, just for this last question here, for final agency decision, it's usually pretty rare that I'm going to recommend that you do that route. Typically, maybe if it's a cut and dry, it's very clear and you have submitted documents that it's a slam dunk. It's, you're able to show that they did X. You have an email, a letter saying that the reason why they took this action was because of your race. If you have something like that, maybe a final agency decision would be recommended. But in most circumstances, there's more pros to going the EEOC hearing route. It's pending litigation, meaning you're going to have leverage with the agency to try to settle your case. At some point there's going to be a neutral third party reviewing your case. They're going to have all of the authority in making decisions, and in that instance, it just has more leverage than giving your case right back to the federal agency you're claiming is the one who discriminated against you. So, there are instances, and it's case by case, but it's rare, in which I'd recommend that you do a final agency decision instead of going to a judge. And with that, I believe that that's all the questions that we have.
Thank you everyone again for joining today's presentation, and thank you Amanda for presenting. This presentation was recorded and a version will be sent via email within the next couple days. I hope everyone has a good rest of their day.